listeners.
Morning.
Radio this morning. My name is Jones Ewa Enano Pay. Yeah, the legal issues nebro Enano Pay. And the Abinelle Solicitors for when we train come up Enano Pay. So I think we do feeding out to her. But more than I said, Obama Ubushan for who or Namu for who said Enano Pay. Near Koso. In terms of legal issue. When it comes to immigration law, family law, the best place to go to Abinelle Solicitors in Tino, Shenenso. Bit means so I share program me our Facebook Live, or called GN Radio UK. Yeah, stream it live our Facebook. I think so. Whilst you're there, don't forget to share, to tell a friend, to tell a friend, to tell a friend. Maybe I'm making why I sorted though, but and I sorted making sure say Obama I'm and so this program is going on. Don't be the only one enjoying this or trying to take advantage of this. Make sure your friends also or family members get to know that this program is currently on GN Radio. You can listen to GN Radio on all apps, especially if you have Apple or if it's a Samsung phone. Google Play Store and also on Tunein. All right. So today on the show, like I said, in terms of Abinelle Solicitors, there's the area of specialty is immigration law, family law. All right. So maybe it would be best before I introduce my guest on the show to give you a bit of information about this particular firm. On my address, 14 Claypole Road, Stratford. E15 2RJ. That is East 15 2RJ Romeo Juliet. On my number, so yeah, 0203 759 3309. Possible. 0203 759 3309. And that's help us off from mobile number 9 078 24 705353. I don't know your office number. Obey me, Afra. Then so no as episode fresh studio here. Unfortunately, I say still, and then so me by engineer I'm almost what to say. We still have a bit of technical issues in they're on there trying to sort it out for us. Nevertheless, Obey me, I get in touch on this number 0778 793 9958. Let me repeat that number again. 0778 793 9958. It'll be to me. After also be to me send no messages also. And I'm not paying the background. I'm trying to come off from Abinelle Solicitors. Amy Adayadente. Amy, good morning.
Good morning, Jones. How are you?
Very well, thank you. And yourself?
I'm doing very well, thank you.
Okay, so today we're going to talk about child citizenship and registration fee waiver. People that want to naturalize and the processes and the requirements. We're going to touch upon that. And quickly, if you've just tuned in on Facebook, please do make sure that you share. Whilst you're there, you can also send in your questions, all right? And we'll do our best to put it to Amy, for Amy to answer all your questions for you. I think before I proceed, it's only right to apologize to our listeners and also viewers, all right? We were a bit late this morning. Please forgive us. There's a few things that we had to make sure was up and running before we came on air, just so we give you a quality show, okay? All right, without further ado, let's proceed with the show this morning, Amy. So, as I did mention, in terms of child citizenship registration fee and also naturalization, let's talk a bit about the updates on child registration, citizenship, and registration fee waiver.
All right. So this is groundbreaking, I would say, because prior to this, if you are a child, you want to register as a British citizen, then you are looking to pay, of course, £1,012. The fees are still very much applicable. You still have to pay the Home Office fee. But what the Home Office have done, conveniently, I would say, is they've introduced a fee waiver. So what that means is if you're the type of person or you are in a situation as a family and you are unable to afford the fees for your child, the Home Office have made it possible for you to apply for a fee waiver for the £1,012 to be waived. So that is excellent. Wow. Of course, you wouldn't qualify automatically. There has to be certain requirements that you need to meet first, but it's still groundbreaking and it's still very good news.
And also, if you can just touch on some of the requirements.
All right. So with this fee waiver, one of the main requirements is the affordability test. You need to be able to meet that. So when they say affordability test, what they're looking for is, can you afford to pay the fees? Would paying the fees affect your ability to provide for your essential needs? Would it put you in a destitute situation? So, for example, you and your partner, or if you're a single parent, you have your income in the form of wages. Now, when you take out all your essential costs, living costs, such as rent, mortgage, food, clothing, council tax, utility bills, when you take out all of that and you have your the balance remaining, it could be either a surplus of a lot of money, maybe £500-600, but in some cases it could be a deficit, which means that after you pay all your bills, you're in the red, you have a negative balance left. The Home Office are looking to see whether what you have left after you've paid all your expenses and all your living costs, whether you are still able to afford the fees. So if you're the type of person that even though at the end of the month you don't have much left, you have savings, you have investments where you have so much there just hiding somewhere in a bank account or an ISA, with that sort of situation, the Home Office may require you to still pay the fees. So they're really looking for people who cannot afford. They don't have savings, they don't have any surplus, a great amount of surplus that they can use to pay. That is what they are looking for, and,
in effect, I'm going to obey income expenditure.
Most definitely. We would always do an income and expenditure with the clients before we put together the fee waiver application.
Okay. All right. It's also so fall into this category and making sure say Obefre Abinelle Solicitors or any questions on Facebook so Amy Nima. You can do it. You can send in a text message or, like I said, via our Facebook, or you can call on 0778 793 9958. Make sure you do so. We'll check our Facebook messages very, very soon. So on the issue of naturalization, so let's move on to that, because you've just spoken about citizenship registration waiver. What is the update and what is the qualifying period, and when can one apply to naturalize?
Okay, so Jones, there's so much involved in the naturalization process.
Right.
What they say is that you ought to have your indefinite for 12 months. That is one of the main parts of the requirements. There's others. I could list them. For example, Omoka said, if I'm speaking tree, you have to, so your life in the UK test. You also have to pass the English language test, or you need to be able to show that you are exempt from the English language test. You qualify under the good character requirement. There's a possibility, say, also that you've been free from any immigration control for 12 months. And no nature said within 12 months after say indefinite, you can then do what? Go for your naturalization. But so Home Office, basically the Home Office guidance, you find out so much, especially the guidance dated 2021. You find out so much that can help you. Naturalization application. To me, wow, almost say they can, the caseworkers, they can use their discretion. Almost bet me, I regard it, for example, naturalization application. Bet me, like I said, first and foremost, no, ebia wo indefinite application no call ye, wo de ko 2 mono. Eko chair wo ho bebre ansana. Omude indefinite decision no ebrel. For that reason, if ebia unya 15 months after say unya sa decision no, you are going in for your naturalization no. Omutimika say because say ude indefinite 2 mono I chair no, they are able to say okay, they can waive their discretion a little bit in giving in allowing you to naturalize before that 12-month period. Also, no, they have a look at other things such as the EU settlement scheme. Ebia now we're permanent residents. Now when him says when your EU settlement scheme into the 30th of June apa home 1 year EU settlement scheme. No, they are saying once you are able to give a reasonable ground as to why you did not apply for the EU settlement on time, no, they can really just overlook that 12 months period that you have to stay for. So, ebia unya EU settlement last month because you applied late.
Yeah.
Late. The amount. But prior to that, now we're permanent residents. Almost say they would not wait. So, will settle status or indefinite leave to remain. In the letter, no, it says you can apply to naturalize 12 months after the decision has been made. Wow. But so you already had permanent residence, but you applied for the EU settlement late. They are saying they can use their discretion to just ignore that 12 months. It means you don't have to wait 12 months. You can go for it immediately after you've received the decision. So you can see, they are trying to bring in a bit of flexibility. You see? And then also, Ebiana, when you're with indefinite, you've had your indefinite for, let's say, 8 months, right? And we all know you need to have it for 12 months before, say, call for British book or red book. But then you feel, okay, let me put in the application for naturalization now. What the Home Office guidance is saying, they say, and at the time of consideration, what per 12 months date, at the time they are going to consider and decide, they should let you have it. It's not that they will look at the data you applied for the naturalization. They will look at the time they are considering it. When they look at the time, say 12 months apart home. So then we can, because these days there are delays at the Home Office. So you may put in the application today, but it will not take the full, it may take more than 6 months. All of that time would be considered when they are looking at your naturalization application. It's in Yaman kitty way, no, and my yemre, and my naturalization process, no, and my yemre. But someone more, but did he say, oh no, I said me 12 months, maybe a British passport, no, they call your BB, and you need it. You don't know that you can make the application even earlier. So Jones, I think there's a way, and they should come and see us. The way and how to go about it to make sure they get what they're looking for.
Absolutely. And I've heard of cases where, I think the last time we spoke about this, where a lot of, especially within the community, amount of people can say, oh, me cry me and send me no. By the time you realize, you made a few errors, or there's certain documents that you did not attach, or you didn't meet the requirements. Just some simple little mistakes that people tend to make without seeking the appropriate advice. Internet for Abinelle Solicitors for Omobebua, making sure so be getting in touch. Meant now and can say, be a Wadam for be an answer for me be until no and no one also be and it's Anshana Nema Akokechi Ama. But Amy, let's move on, because there's a few questions here that I would like to put to you, and hopefully you'll be able to shed some more light on this.
Okay.
And it's in question number one, say a Ghanaian national has just had a child with a British citizen. There has been domestic violence at home. Due to the tensions between the couple, the father of the child has sworn not to get the child a British passport until the child is old enough. He claims he's doing this to punish the mother and to ensure she remains in the UK unlawfully. She needs advice.
Wow, Jones. Asem way there, a tassi pound. But fresh.
Yeah.
By the grace of God, one of the parents, no, you're British. It's nature say, ya wona to honor, or not to bet me and your British passport. Now, here's the case that ebia mameno onibi inti or train say akolano benyan the British passport na wajina akolano so edian anyanedia.
Yeah.
But we have to understand, say, of course, who your British passport, you need the consent of the British national, in this case, the father. Indeed, the question is, Jones, what do you do? What do you do?
Yeah.
Well, Jones, there's a way.
Okay.
You can go through the family court. You can. To be honest, before you go through the family court, you should try and settle amicably anyway.
Yeah.
You can go through mediation. But if still, or insist to say, there's a way that you can go through the family court and specifically ask the court to ensure that the father registers or applies for the British passport for the child, and that is called a specific issue order, letting the court specifically to order the father to do something for the child. So where you feel like there's no way out and you're unable to make the application without the father is being, or the mother is being difficult, on my birth certificate, on my copy of the passport, just say, on person or bed wow in any way, shape or form, we have to remember, say, there's a way out. We can go through the family court to resolve this. The family court can oblige father to make sure, say, obey a passport, no, I'm a collabo. So that is one of the ways in which you can get around it.
Wow. It's interesting because Sanyama saying, we've heard so many times about issues, say, happen, especially, say, if parents, for some reason or another, then there becomes there's tension. And then now, of course, it's almost like they're trying to, like point scoring. For there's a way. There's a way. It's more than some friend. Abinelle Solicitors. I remember numbers needs to be you. Open send a text message at number 0778 793 9658 0778 793 9958. Betsy me ask message. Now here we do. I'm obviously streaming live on Facebook. Mr. Ma streaming live on Facebook. Go on my make sure say over share. I face question be answer a bit me post to Facebook now. Area to now with me answer. All right then. Another question, Amy.
Yeah.
Yes, sir. So the mother has registered the birth of the child. However, she's being terrorized by the child's father on a daily basis. Unfortunately, she has nowhere to go. An alternative safe place for herself and a child. What can she do to prevent further harm from the father or her child? And also, she fears, sir, as she has no leave in the UK, she has no rights. And again, this is something, of course, within the community, say, be one of my only and characters, no leave to remain in the country now. As I'm not a who be a calm, now they're just suffering in silence.
Jones, you get a lot of cases because tenancy agreements into ɛna oni baby fufura obekwa koda inti say no oyɛ den well metimi aka say in this situation we have to understand say a domestic violence sometimes no Jones in the community in our community no domestic violence cry sia no omodi sie say any domestic violence obi person can be man of poor obeka say enye hwe but Jones in such a situation you need to not only protect yourself but akolano nso ese akolano onya safety ni protection the best interest of the child in a situation like that no what you can do no say whether you have or you do not have leave if you are being you're embroiled in domestic violence, through the family court, again, you can apply for something called a non-molestation order. Some non-molestation order within the family court setting. The court will order, say, the person, the perpetrator, the violent or fear, stopping the actions of violence towards you. Inti se obo debia or pancho or kiki whatever he's doing no a best man order says sadiana or on refraining from sadian. In fact, a court deeper, a man some proximity inti mika proximity ebia unine wo fear ebeka say ebia ubetimi and yes obeba within a certain radius of you inti ontimi beben krana adena asa asojabium debi they give that restriction which protects protective no ba apart from that and so say bibia say oni wo fie ho there's a chance say violence be sa koso biom omo betimi ama bibia your friend non-molestation occupation order non-occupation order an occupation order which will give you and one oba ebema what such chance to say mumu na mube occupies our property no inti any few and any few you bet remove it or no it's not always so because they look at the circumstances of the perpetrator. They look at ebi ombehwe bema no say owaska no or betimi relocating and now alternative accommodation you behwe nya no financial situation. And in this case, wuni stay no, wuni ebia wuni ejuma awoye. Unso wuni baby awotna. Unso awopa wa wono fufuro. Inti family court no mbehwe ade no a check say a beneficial say woman na mobile mouse occupation rights no to exclude the other person. Inti in this situation, if it looks like he is working, he has alternative accommodation. You are not working, they would look to protect you. The chances of being protected is very high. Yenkai said there are orders that could be made by the family court to protect you both against violence and to give you a place to stay without having to include the other person. There's a way.
And to know if I'm getting you correctly now, Amy, are you saying, sir, in environment which is not conducive and there's been a consistent level of abuse in the domestic violence settings, I'm fine say omuoba and my many in Krata still legally, no, there's a way she could be protected. On an neighbor could be protected because one can only assume that in that predicament, you know, ABI out in the whole choir, she might get deported.
Oh, yes, of course. Our krumha abra only in krata. So that one from day one or overstay or krumha no ombet me afana kofi. But in this case, no, this is a family law issue, first and foremost. And more importantly, no, as the child is, virtually British, or not a British passport yet, but by virtue of ne papa no, or you're British, no, there would be that interest in ensuring, say, the parent or share kolano, or no, so no hobetono, or once or a vulnerable person with, or not vulnerable person, and the child is vulnerable at this stage. Say the best interest of the child is paramount in this case. Say you are protected to ensure the child too will be safe and be protected in this situation as well.
Well, that's very interesting, and I think it's very, very important. It's in the for Abinelle Solicitors for any train come and then pay. You say offer or more office now 0203 759 3309. Misambo Sibium 0203 759 3309. Mobile number Nancy 078 24 705 353 078 24 705353. But studio had the opposite offer and I say send a message. Number is 077 879 39958. I'm Sambo Sibium 077 879 39958. Mr. Wa will be to me. After and I say also be to me. I send a message. Now you redo messages. Now I say questions. No, there are two. Amy and him now with me and Sam. Another question, Amy. A father of 3 British children has been thrown out of his matrimonial home due to infidelity. Or say his wife has sworn that he will never see the children until they are adults. There's a lot of hostility between the couple, and he has been banned from the family home. His wife has also stated that she will not assist her husband with his immigration application, as she's going to withhold all children's passports and birth certificates. She has gone to the school and told them that the father should not be allowed to see the children. I don't swear.
Jones, and also, there's a way that it can be resolved. Of course, at first instance, no. You can't see the children, you can't come to the house, you can't go to the school. Yes, but we have to remember, say, Papa also what parental responsibility for children. So on to me, can say, okay, it doesn't work that way. Before say Ebeko court, before it gets to court, there would be a mind, which is mediation. They would try say omotu beboom. I try say ombe trash out issues ninya, because their family court no pen say omo pese said bibi ye bet me as settle out of court omo pen far more say ombe settle out of court rather than say ombe taking it through the court. Reason being, first of all, Uko court, the expense is very high, it's very expensive. Second, a lot of time. It takes a lot of time to resolve the issue once it gets to court. And then third, and so a destroyed, once you get to court, now unfortunately, sometimes it may destroy the relationship. It even makes it even worse, because it's like, so much is revealed and it can damage the relationship even further.
Sure. So
to avoid these things, they like you to go through mediation, which is a mind first. Usually these days, it even can be via video link, via Zoom. Mediation for say issues, whether say there's infidelity or whatever it may be, whether they can resolve it in the best interest of the children. Whether say that can be put aside. Na omotimi ati omoho say in kolana die omunka humbi, although say infidelity about, we understand the relationship no about to an end. However, in kolana die etimi hwene ye na de bia papa no ni mame no omotimi coming together to raise the children. So they will definitely give it a good go. If at that stage, Jones, Omo to me agree, said, oh, fine, yeah, we de yatiasie, you who say, okay, bone be about our renum, and yeah, ama our rena say. However, children no dear, every weekend, dear, ni papa bet me about the fan colano, or bet me ako school ho ako huma colano. And then alongside that, they can also go for parents' evenings and other school activities, for example. But once that's agreed, I don't think it should ever be agreed orally. So more peniso into no because Jones in comfort to Mrs. on one drain.
Yeah.
One day no or more peniso bibia kama. Almost sorry next month, boy for more kai infidelity no. Inti omo asamba bium almost they be no, then it's really a cause 90. You've wasted a lot of time and you've not been able to resolve the issue. So what you should do is say, so with mediation now, you can put it into something called a consent order, which will set out everything. When you can pick the child up, when you can take the child on holiday, how long you can have the child for during the holidays, such as summer holidays, Christmas, whether you see the children fortnightly or monthly, you put it into a consent order. The reason why I'm saying consent order, a consent order is legally binding. It's legally binding. Whereas just word of mouth, or just it coming from you, your word, you can go against that. Okay. So that is one of the ways. However, sometimes with mediation, unfortunately, it's not successful. When you get to mediation, still other parties cannot agree. Yeah. Still, I'm going to mean boom and your decision. So, now it cannot be resolved at that stage. At honor, now what to me the court to go and resolve it within or at family court.
Okay, minya text message be wahanomo. From James, to know, if you can just bear with me to be able to read it. It seems a bit long. Maybe I'll see if I can try and summarize it quickly for us. So this is from James. Yeah, James is saying that he's been married. Him and his wife have been married for 17 years. They have 2 children. As of late, things have gotten progressively worse. His wife has reported him for domestic violence, and as a result, has left the house with both children. He's aware, he's been told that his wife is now residing at her mother's place. And the journey from the mother's place to where the kids go to school is very far. Secondly, the wife has not given him the chance to speak or see the children. Every time he tries to contact the children, the lines has been cut off or his number has been blocked. What does he do? A week ago, he received a letter from the court being summoned to go to court for domestic abuse. What should he do?
Okay. What I think he should do is he should definitely give us a call and come and see us. It's definitely something we can help with. In respect to the domestic violence, I would want to know a lot more as to what has transpired before I can really advise him. So if he can give me a call on my office mobile after the program, I would really take him through what we need to do to make sure everything works out.
Okay. James, make sure you call. The number is 07824 70 5353. 07824 70 5353. I think this case needs more time. Okay, let's take another message. Very soon, we're gonna take a quick break and we'll come back. We'll be off for a couple of minutes and we will come back. But this is from Michael. Michael is saying that my wife and my wife has moved out of the house. We have 3 children. I've tried every way possible to make contact with the children. Unfortunately, I have not been successful. Lately, she contacted me after months without seeing my children and finally giving me access to the children. We've tried mediation, but at any given moment, things could start all over again. What do I do? Should I take the case to court? Should I fight for full custody? What would you advise I do?
Okay. It's a good thing, sir. He's tried mediation. If he goes through the mine and he's able to get a certificate that says, sir, they have tried this form of mediation and it didn't work, then it gives him that opportunity to apply for a child arrangements order. I would say if he does have that mine certificate, he should apply for child arrangements order if it's not been resolved. Because if she's allowing you to see the children now, that's very good and it's progress. However, should it go back to the way it's been over the past couple of months or years, I don't know if he would be very happy with it. So to resolve it entirely, I think go through the MIME. If you already have the MIME certificate, he should really go for the child arrangement order so that it's something that's legally binding and it would oblige his partner or his wife to allow him see the children.
All right, Amy. So we're just going to come off Zoom. Make sure you reconnect again, Amy. This is GN Radio. You're listening to John Sewa. Today, our guest is Amy Adai-Dente from Abinelle Solicitors. Their specialty is immigration law and family law. Now, no pay about naturalization and also you happen to find yourself in a domestic violence situation. You think that there's no way, there is a way. Contact Abinelle Solicitors. They will be more than happy to assist you. We're taking a quick break. When we come back, we will continue with the discussion.
You are now listening to DJ Quams live in the mix.
Oye kokoko seme shi ano anka mewu ajinkwe biya menya me yo kokoko seme shi ano anka mewu seme nya no kameni seme neta seme shi ano kama
You are listening to GN Radio UK.
Welcome back. My name is John Sewa. This is Legal Hour, GN Radio UK. Today we're speaking to Abinelle Solicitors. The area of specialty is immigration law and family law. Today our guest is Amy Adai-Dente from Abinelle Solicitors. Well, my address no, 14 Claypole Road, Stratford, East 17 2RJ. That is 2 Romeo Juliet. On my office number here 0203 759 3309. 0203 759 3309. Also 078 24 70 5353. To Bomodian said Obe from any issues relating to immigration law and family law. So, before we went off, once again, welcome back, Amy. Before we went off, prior to say me Bissau, a couple of questions from Michael, any James, Now, about a father of 3. He's been thrown out of his matrimonial home due to infidelity. His wife has sworn that he will never see the children until they are adult. There is a lot of hostility between the couple, and he has been banned from the family home. His wife has also stated that she would not assist her husband with his immigration application, as she is going to withhold all children's passports and birth certificate. She has gone to school and also told them that the father should not be allowed to see the children. And following up, it says here, in terms of this particular case, what does the father do now to make an application to the court to see his children immediately, and what is the procedure?
Jones, the procedure would be to go through the mime first.
Okay.
So they are going to try and mediate to see if they can both agree. For the sake of the children, to see if it can be resolved. If it's resolved at that point, I would always say that it should be put into a consent order to make sure that whatever is agreed is legally binding, and the person will know that the court has ordered for the other party to be involved in the children's life in that specific way. Okay, so that is, for me, the best solution. However, sometimes when you go for mediation, the parties involved can agree amicably. Mediation, they don't see eye to eye.
Sure.
That's 1. 2, sometimes when you even attempt to get the person involved in the mine, they just ignore it. They don't even, they're still being hostile. So they just ignore any sort of opportunity. For mediation, they just ignore. And then it means, obviously, the other parties still are on to me. If that happens, they would usually give you the mine when you approach them and the other party is not participating. They'll give you a certificate. You can then go forward to start your child arrangement order proceedings against the person. So that is a family application. Give it to me, at all, to give you the chance to see your children.
And in these circumstances, does that the actions of the father, can the mother use that as a right to restrict the father from seeing the children? In this case, the issue with infidelity.
The answer to that is no, because if you look at the fundamental principles behind family law, what it says is the paramountcy in respect to children is the welfare. The welfare of the children is paramount in everything. So infidelity has absolutely nothing to do with the child. So therefore, the courts would not take that into consideration, really, unless maybe, for example, infidelity brings about another partner that is having an ultimate effect on the welfare of the children. That's completely different. That would be resolved when you're at court or during mediation. But if it's just infidelity, it has nothing to do with the children. They're never going to stop one party from seeing their children because of infidelity. So, Jones, what I can say today, and I'm going to say it so that we can really get this understanding, is Mayan use it in Kola as tools. Mayan use it in Kola as weapons. They are not there for that purpose.
All right. Let me just interject. I will bring you back just to run up on that. We're taking a quick break. When we come back, we'll continue. This is GN Radio. We'll be back shortly.
I take the game. I am a connotor. I think the dumb to say I'm a I am the fellow to I say I'm a security. When I get down, opportunity, goodness and mercy. I'll follow
Welcome back to GN Radio. Midin Eddie Jones and Nano Pay. GN Radio UK Legal Awan Yadu Ebremui. Yane Abinelle Solicitors for Netrin Coma. Amy Ade Dente and Ojini Mama Abinelle Solicitors. Area of specialty immigration law and family law. Amy, before I yoko break no, and you were making a very important point and I interjected. So if you can carry on.
All right. Yes. No point and may try say may explain say man using Nkola as tools or as weapons against parents is just wrong. Although say ebia na aware no no BBSC ama mumie no muntema ye basa but eno nkyerɛ sɛ Nkola no ɛsɛ ɔmo suffer. The Colano is almost suffer because of that. Because remember, say, quarter, all your personal feelings will be put aside, and the welfare principle will take place. It will be enforced in the family court, which means, say, almost share the welfare of the child, almost share a Colano mon or only interest, the best interest of the child, almost share say a Colano mon no hubetono. Or no, obenya a balanced upbringing. Se me can balance that. Se ni mama ni papa tiasia. Omubeshe se ni mama betimi ahono. Ni papa nso betimi ahono. So don't ever feel say you have more of a right over one particular parent. Both parents, if you both have parental responsibility, then you both have that right over the children. Into the nyano to protect or prevent another party, another parent from seeing the child. You know, remember that when the court get involved or when mediation or the court are involved, they will make sure say to the point in which you are thinking just about the children and how your children will be faring, not you. I thought say I should add that to it because Jones, the abuse and the worry, the anxieties, because it's just in our community, it's very, very high. We have a lot of such issues.
Yeah. And I mean, found a message from our Facebook. Could you say good morning, host and Amy? I renewed my limited leave for the third time. I made application on time within the last 28 days. The decision came out in 9 months. However, the caseworker did not include the 9 months when my application was with the Home Office. So I have extra 9 months added to my years. What can I do?
Well, the consideration time is not something that they're going to deduct from it all. They're not going to do that because the Home Office reserve the right, or more right to say they will use a certain amount of time, whether it's within the 6 months time frame or it goes even for a longer period of time. They're not going to take away such time at all. They're not going to do that. So what we really have to focus on is we need to focus on whether you've done your 10 years lawful residence, whichever that route is under, whether it be parent or partner. You need to focus on the fact that you've done the 2.5 years on 4 occasions and you've made in-time applications. When it gets to the anniversary of the 10th year, where you've done your 10 years lawful residence, you can apply for your indefinite. But any time in between that it takes them to consider the application, they are not going to deduct that. they're not going to deduct that from it. You need to do 10 years lawful residence under the particular route, whether it's private life, parent, or partner. You need to do 10 years. So you need to do it 4 times. So once you've done it 4 times, it equals 10 years lawful residence. You then can apply for your indefinite. But anytime they use in considering the application, and it's not going to, they're not going to deduct that, unfortunately.
Okay, could you hope that answers your question? Of course, if you need more clarity now, it's me, Afria, Abinelle Solicitors. Mobile number is 078 24 705353 07824705353. Another message from Emmanuel, Facebook. I say, can I sponsor my brother financially to study in the UK? He's in Ghana and has 1 degree. I think this we kind of touched upon this last week.
Yes, I mean, if it's like, I would say, they normally look for it to be like a parent or so on and so forth. But I mean, if it's, let's say, for example, it's a gift you're going to sponsor brother, and it's a gift you're giving to him, you can actually declare it as a gift, or you give the money to your brother and you put it in his account and he's going to use it for whatever he needs to, which is, he's got a degree for his master's, then I don't see why there would be too much of a problem. But I think it's very important that you declare it is a gift. If it's a gift and there's no further consideration with it, I think it should be okay.
Okay, a message from Jackie. Jackie is saying that her sister had her documents, her papers, back in 2012. However, she went through severe mental health issues and was unable to renew her documents. She's just received a letter from Beckett House that at any given moment she could be removed from the country. But she had her indefinite leave to remain. It's just that due to her circumstances, she was unable to renew her visa. Any advice?
She had indefinite leave to remain.
Yeah.
Okay, if she had indefinite leave to remain, it really depends. I would like to know a little bit more. So if Jackie can give me a call, because I would want to know whether it's under the EU settlement scheme.
Okay, she just texted. She said that she was renewing it every 2 years. Then they went to 4 years.
Every 2.5 years.
Yeah.
She was renewing it every 2.5 years, and she got to 4 years and she stopped.
Yes.
Okay. Well, there are quite some strict rules on lawful residence before you can apply for your indefinite leave to remain. If there are any breaks in the continuity of lawful residence, it can go against you when you're applying for your indefinite leave to remain. So in this situation, ideally what she should do, because at the moment she would be considered to be an overstayer at this point. So what she should do, based on what is the basis of why she's applying for leave to remain, she should try to reapply again. I think what Jackie should do is, if she can kindly give me a call, I'll be able to take her through what we need to do to make sure her sister is able to regularize her stay again, and to really mitigate her circumstances. She should give me a call.
Okay, so the number to do so to reach Amy is 078 24 705353 07824705353. This is from Nana Ajiman. Nana Ajiman is saying, what requirements do I need to remove no recourse to public funds from my 2.5 years visa?
Okay, requirements, right. So as we all know, it's automatic. Once they put the restriction on your leave, they put it on if once you apply, they just put it on. If you've not applied, to take it off. So if you want to remove that restriction or condition on your leave, what you need to do is you need to demonstrate to the Home Office that you're destitute. One, destitute if you can afford your rent, but you can't afford your other essential living needs, or you cannot afford your rent, but you can afford your other essential living needs. You see, so all of this, they're looking at your financial circumstances, your financial health. They would want to see your 6 months bank statements. They would want to see any other UK accounts that you may have. It might be a joint account, a savings account. They would want to see, to check and check to see whether, at the moment you're able to sustain without their help or assistance. They would want to know a little bit about your accommodation, whether you are living with friends, with family, whether you are able to pay your rent. Mostly what we do is we do an income and expenditure, letting them know, although you're working, once you take out your essential needs, you're basically in the red. It's difficult to sustain. This is what they want to see. They want to see your financial conditions after any income that you have, after you've taken out your expenses. How are you faring? And also they want to see the impact that has on children, okay, in the UK that are living with you, your dependents. What impact does that have on the children as well? So Nanajiman, I think if you'd want to do that, please kindly give us a call and we'll take you through the process.
Okay, this is from Kwame. Kwame is saying that he invited his friend over, but a few months, 2 months into his friend staying with him, they fell out. Now he doesn't know his friend's whereabouts, and he's wondering, in case his friend decides to overstay his visit, what implications would he have, and how would that affect him being here?
Okay, so we have to always remember that if you invite someone to the UK, it is their responsibility to make sure they do not breach the conditions of their leave, which is, of course, in some cases, a visitor's visa. If his friend overstays, it will have an adverse impact on that person's immigration history, okay? And they may be liable to be removed or deported. It will not have an adverse impact on you, because although you've invited the person, for a period of time. If they decide to overstay, then of course the burden would rest with the person who's overstaying, and not so much with you, because you cannot control people's actions. He said he would stay for 2 weeks, but he ends up staying for 10 years. You cannot literally force the person to travel back to their home country. However, it would have more of an implication on the person's immigration history than anything at all.
Okay, and I think this will probably be the final question we take from Facebook. The person is asking, can I invite 2 people simultaneously?
Can he? Yes, he can. Yes. There's nothing wrong with that. But it of course, it would obviously depend on whether the person can meet the rules under Appendix V. 1, do they have a genuine intention to visit the UK? Which means when they come, would they go back to their home country? 2, they would want to know their maintenance financially. Would they be able to maintain themselves when they come to the UK? If you are the one sponsoring, and you are sponsoring, you're like a third party sponsor, and you're sponsoring financially, then you would need to demonstrate that you'd be able to cater for both of them when they come on holiday, not just one person. So these are the things they're looking for. If you are not sponsoring financially and they are financing their own trip, then all you need to do is to show that you are inviting them. If you have a place for them to stay, you prove that they would have adequate accommodation once they arrive in the UK.
All right. Amy, thank you very much for joining us this morning. Yo, it's for Enano Pay, Yene, Amy, Adai Dente, and a Chuchenkumo. a free Abinelle Solicitors on more area, on more dealing with immigration law and a family law. One more address, 14 Claypole Road, Stratford, E15 2RJ. And the Echo 15 to Romeo Juliet. On my office number, I see it 0203 759 3309. 0203 759 3309. And that mobile number, I see it 078 247 05353. 078-247-05353. Nti no beti me a contact you. Medin Eddie Jones Ewa. Ahana Eddie Ejumedi ABC. Make sure you stay tuned. Yamiya Aduma Wednesday. We're starting our new show, the GN Morning Breakfast Show, with myself, bringing you current issues and also trending issues across the globe, with a main focus on African issues and also, in particular, Ghana. So we'll do this again next week, Monday, with Abinelle Solicitors. Enjoy the rest of your day and stay safe. Thank you. Goodbye. Jehovah.